clarification I made before Your Honour rose for lunch. That was that the members of the TRG who'd made statements should be called. Your Honour hasn't ruled on that yet, but I'm happy to refine that application to an application to recall Mr. Meacham King, because after all, he's the one that gave the final statement in this series of statutory declarations where no one knew anything of the TRG, and Mr. Meacham King finally acknowledged that he had actually been the presenter and created the presentations for TRG awards from 2015 to 2022. So, in my respectful submission, Mr. Meacham King has a lot to answer for, having made statutory declarations where he said, in effect, to this inquest, I know nothing about any racist content of any of these awards, to his final statement, a statutory declaration, 1st of May, where he now says that he does, and that should be explored.
Do you wish to put on any additional written application or submissions, or are you content with that application and submission? Mr. Abbott?
May I ask why then?
Sure.
I'm happy for my oral application to be substituted, to be instead of a written application, Your Honour, to deal with on that basis, having regard to, and after Your Honour's further consideration of the difference between Mr. Meacham King's first and second statutory declarations and his third statutory declaration.
Thanks for putting that on the record. Obviously, all the parties are now advised of that, and we will invite written responses with a very short timetable, and so I can consider the position. In relation to the other matters that have been raised, firstly, in relation to the notes that Mr. Rolfe accessed when giving evidence on the last occasion. In the inquest into the death of Kumanjayi Walker, ruling number 10, I dismissed an application by Mr. Rolfe to be excused from compliance with a call by the Northern Territory Police Force for the production of a set of notes from which Mr. Rolfe had read while giving evidence. The only basis upon which Mr. Rolfe sought to be excused from compliance was that the notes were the subject of legal professional privilege. For the reasons given in ruling number 10, the claim of legal professional privilege failed. Accordingly, I ordered that Mr. Rolfe produce the notes in answer to the call. Because of the way my order for production was framed, the notes were produced directly to the Northern Territory Police Force. On the 22nd of May 2024, the North Australian Aboriginal Justice Agency, or NAJA, wrote to the court seeking an order for access to the notes produced in answer to the Northern Territory Police Force's call, although several parties had put on submissions in relation to that call previously, which indicated their interest in the notes. Because the notes were produced directly to the Northern Territory Police Force rather than the court, this request for access was framed as a request for a direction that the Northern Territory Police Force produce the notes to the other interested parties. The Northern Territory Police Force neither consents to nor opposes the direction, but Mr. Rolfe opposes it. The only basis for Mr. Rolfe's opposition is that the application is very late. In submissions referred to as an ambush, and as such is productive of unfairness. I reject this submission. It was clear from the outset that other interested parties, such as the North Australian Justice Agency, the Walker Lane and Robertson families, and the Brown families, also sought access to the notes. NAJA filed detailed written submissions opposing Mr. Rolfe's application. The families stated expressly that if the remainder of the document is produced, the Walker Lane Robertson families seek the opportunity to view their contents to inform whether any other issues arise in respect of Mr. Rolfe's further testimony. Mr. Rolfe had the opportunity to and did respond to those submissions in some detail. At no point did Mr Rolfe suggest that were I to dismiss his application and uphold the call, that there would be some additional unfairness arising from the provision of the notes to Naja and the families. Mr Rolfe's submissions on the prejudice or unfairness said to arise from Naja's application and the other applications were somewhat difficult to follow. Mr Rolfe complained that the notes might prompt an application for leave to further cross-examine him and that any such cross-examination would be unfair. The principal difficulty with this submission is that Naja has foreshadowed no such application and nor has anybody else. In any event, whether any further cross-examination would be unfair is a question that would be determined on an application for such leave if it was made. Naja and the other interested parties have a legitimate forensic purpose in seeking access to the documents. Given what was contained in the first 3 pages, it is very much on the cards that the notes are relevant to issues important to this inquest. In circumstances where I have already discussed Mr Rolfe's claim of legal professional privilege and where Mr Rolfe does not identify any other basis upon which he could resist a call by the interested parties, I am comfortably satisfied that they have a proper basis to call for the notes. Accordingly, I order that Mr Rolfe produce the notes to the court so they can be made available to the interested parties. In doing so, I also make a non-publication order in the terms outlined as discussed by counsel assisting before lunch, which are consistent with the previous similar non-publication orders. Concerning the statement of Kerry Joy dated the 20th of May 24, and which was served on parties on Friday the 24th of May 24, I have carefully considered the submissions and arguments of counsel. I am persuaded that paragraphs 1 through to 63, except for paragraph 57, should be admitted into the brief of evidence. Those paragraphs largely refer to matters in Mr Joy's direct knowledge and include some matters against his own interest. For example, they include his knowledge of the workings of the TRG during his police service and to some extent thereafter, and they include his admissions and knowledge concerning the use of racist language. Concerning his conversation with Commissioner Murphy, he reports his direct participation in that conversation, and Commissioner Murphy will be afforded procedural fairness and given an opportunity to respond. Paragraph 57 is the exception. It contains hearsay assertions that cannot be easily tested and about which I have received no other evidence. In those circumstances, I could give that hearsay no weight and I will not receive it. With respect to the remaining paragraphs, including paragraphs 105 to 121, I have considered the submissions of Mr Abbott, but I do not consider the information contained in these paragraphs will assist me in my duties. It is primarily Mr Joy's opinions which are given when he does not have privy to all or even most of the evidence received in this inquest. In particular, concerning the events of the 9th of November, Mr Joy was not a serving member of the police force and had not been for some years, nor was he present. By contrast, I have ample evidence from persons present and from others who have direct knowledge of the events, all of whom provided timely statements and were available for examination in a way that provided procedural fairness to all. Accordingly, I decline to admit paragraphs 64 to 125. I will adjourn very briefly, and just so those notes can be produced and provided to the parties, and then we will resume. Mr Rolf seconds.
Your Honour, the notes in fact consist of 12 pages. I know they've been referred to as 10. That's an error, and the 12 pages will be produced as they have been produced to Dr. Frick.
Thank you. We'll just adjourn for, I can say 10 to 15 minutes so that the notes can be provided.
You've got copies of them.
How do you want to